Okay, hello and welcome to the new FCCJ. I'm Abby Leonard. I'm the first vice president here, and I'm pleased to be moderating today's event. So we are welcoming Hiroki Sakakibara, an in-house counsel for Olympus, who's here today in a whistleblower capacity. Everyone here is probably already familiar with the Olympus scandal of 2011, when former chief executive Michael Woodford exposed his colleagues for falsifying accounts to conceal losses of nearly $2 billion. It was one of the biggest financial frauds in Japan's history. And today we're here to talk about another issue, related to another issue, not exclusive to this issue, but this one in China. Olympus is alleged to have made illicit payments to a fixer to resolve problems the company was having with Chinese customs authorities. Olympus has said it investigated the allegations and dealt with them, but our guest today disputes that and says that there's been retaliation inside the company and that the issues are still very much ongoing. So with that, I will hand it over to him. Sakakibara-sensei, thank you very much.
Good afternoon, ladies and gentlemen. Thank you for giving me this opportunity to speak my story of Olympus. First, when I speak English, my English is not perfect, so sometimes you may have some questions during my speech. I'm sorry to say beforehand, but I will be glad to explain you later in the Q&A with Mr. Waku's help. As my brief self-introduction, I'm a registered Japanese lawyer and joined Olympus in June 2016. Since I joined Olympus, I belong to the litigation team in the legal department. My major role was handling the duodenoscope lawsuits in the U.S. And for the last 1 year, I'm also working on the whistleblower in the Shenzhen bribery issue. And right now, I'm filing the lawsuit against the company because of the retaliation against me. And for the last 7 months, I am locked out of the company, and the company hasn't taken any further actions. I believe this doesn't make sense, but the company is continuing this situation. Perhaps maybe they are waiting for me to leave the company or waiting for the conclusion of my lawsuit. The reason I'm here today to speak, aside from my lawsuit, is that I would like to share with you the serious risk that Olympus is now facing. Just to introduce, there was a 2011 scandal which was revealed by Mr. Woodford, the ex-CEO of Olympus Corporation. He revealed the $1.7 billion accounting fraud, which led to the arrestment of senior executives, and also the company being at the stake of being delisted from Tokyo Stock Exchange, Section 1. The investigation report of 2011, so-called Kainaka report, often talk this in the company, criticized the Olympus's corporate governance with straightforward words such as rotten to the core. Today, I wouldn't say that Olympus is still rotten, but I cannot but say that even though Olympus promised to rebuild its corporate governance after the 2011 scandal, the company hasn't changed. Maybe it's still getting worse. And now I'm thinking that the company's corporate governance is questioned by the three big issues. The title of today's conference only refers to the Shenzhen bribery issue, but here I would like to say that the bribery issue could be connected to the other issues, and all those three issues could be a series. First, Shenzhen bribery issue. This is a potential bribery to the Chinese government official through the local consultancy. Two, DPA issue. This is the potential breach of the deferred prosecution agreement signed between Olympus and the United States Department of Justice for the illegal kickback which occurred even at the same time of the financial scandal. And 3, the ordinal scope issue. This is the ongoing issue. It is the outbreak of a multi-drug resistant superbug spread from Europe and then to the America. For what I would like to say here, that all these 3 issues are concerns U.S. laws and are monitored by the U.S. Department of Justice. And I believe that the Department of Justice is questioning Olympus's corporate culture in some events, explicitly or implicitly. So this is serious because Olympus's profit relies largely on the sales of the endoscope in the U.S. market. So for avoiding the risk of tragedy to the Olympus, especially in the U.S., I would like to say that the Olympus should rebuild its corporate culture and also the corporate governance and deal with these 3 issues properly. That's the main point of my today's conference, and from now I would like to explain the three issues in the historical order. I expect you have handouts I provided previously. There's some chronology of the 3 issues, and what I'm trying to illustrate is that all these 3 issues are monitored by the U.S. Department of Justice. The colored line means that an issue is not investigated openly, and in the dotted line, that issue could be monitored implicitly. So for now, here I would like to briefly explain these 3 issues. So before 2010, before the 2011 scandal, Olympus Tokyo structured so-called Tobashi scheme to divert its investment loss to the offshore companies. But actually, at the same time, there was 2 issues ongoing outside Japan. In China, the Chinese subsidiary Olympus Shenzhen Industrial, so-called OSD, was facing was dispute with the Chinese customs authority for its mistake in the factory's inventory records. This is so-called customs issue. And also in North and South America, Olympus's U.S. subsidiary Olympus Corporation of America and also Olympus Latin America, we call OCA and OLA, were providing illegal kickbacks to the healthcare professionals to obtain a business opportunity in the North and South American market. So before 2010, there was actually 3 scandals ongoing. And in 2011, 2 issues were revealed. In 2011, in Olympus Tokyo, Mr. Woodford's whistleblowing, and this revealed the accounting fraud. And in U.S., the Department of Justice issued a subpoena and started investigation on the illegal kickback issue. And this kickback issue could be the potential violation of Anti-Kickback Statute and U.S. Foreign Corrupt Practices Act, which this is an important point to connect this DPA issue and Shenzhen bribery issue. And also in 2011, aside from the customs issue, OSZ started dealing with the local consultancy called An Yuan to solve the fire investigation, its fire inspecting issue that's aside from the customs issue. But this connection in future went to the consultancy to solve the customs issue. In 2012, after Mr. Woodford's whistleblowing, Olympus Tokyo announced the new management's Mr. Hiroyuki Sasa, CEO, and Mr. Kimoto from Mitsui Sumitomo Bank, and Mr. Fujitsuka from Mitsubishi UFJ Bank are all appointed as the director, and Mr. Sumitaka Fujita from Itochu Corporation and Mr. Shiro Hiruta from Asahi Kasei were appointed as outside directors to supervise Olympus's governance. But in 2012, new issues occurred. That's the superbug issue, duodenoscope issue. The superbug outbreak started in Europe, and this outbreak spread to US and continued until 2015. In 2013, even under the new management of Olympus, this Shenzhen bribery issue went worse. The Anpintai, which is a shell company of An Yuan, started to provide consulting services for OSZ to solve the customs issue. And indeed, the new Olympus management, this includes Mr. Kimoto, Mr. Fujitsuka, Mr. Sasa, Mr. Takeuchi, now the CFO, Mr. Hirata, Chief Administrative Officers, and also other managements all approved retaining APT. But actually, the regional headquarters of Olympus, Olympus Corporation for Asia Pacific, the management of OCAP voiced concerns of the potential bribery by retaining APT. In 2014, OCAP legal department obtained 2 memoranda from U.S. law firms, one from Squire Patton Boggs, one from Baker and McKenzie. Both memoranda pointed out high risk of Foreign Corrupt Practices Act violation and recommended to stop dealing with APT. But Olympus Tokyo and OSZ overrode this OCAP management's voice and signed consultancy agreement, and also the supplemental agreement to that. Under that supplemental agreement, OSZ will transfer its dormitories at book price to APT. This could be a very large profit if that transfer is done right now. And then the customs issue was closed with no monetary sanction, and by that, OSZ paid $3.7 million in cash based on the consultancy agreement. In 2015, OCAP Legal continued voicing the risk of a FCPA violation. And finally, Olympus Tokyo started the internal investigation by hiring 2 law firms, one Sherman Sterling, one Nishimura Asahi. And at the same time, Olympus reported this investigation to the Department of Justice. As I explained, that at this time, the Department of Justice was also investigating on the kickback issues. So the kickback issue relates to FCPA violation, and this internal investigation also relates to FCPA violation. And so this is the time that U.S. Department of Justice realized the Shenzhen issue. And also, the duodenoscope issue was also getting worse. Developed. The U.S. Department of Justice issued subpoena and started official investigation on this issue. This duodenoscope issue relates to violation of Federal Food, Drug, and Cosmetic Act. And The internal investigation of the Shenzhen bribery issue was completed, but no public release was done by the company or any decision in this FCPA violation. In 2016, the Department of Justice took an action on the kickback issue. As the settlement, the Department of Justice entered into the deferred prosecution agreement with OCA and OLA. This agreement is to cease the criminal indictment for the illegal kickback based on the AKS violation and the FCPA violation. But in terms of that, Olympus was obligated to establish effective compliance program to prevent and detect AKS violation and FCPA violation. And the important point is this compliance program to detect FCPA violation is not only limited to the OCA and OLA, but also Olympus Group, including OSZ. So this means that if OSZ violated FCPA, that means that OCA and OLA breached this deferred prosecution agreement. And the Department of Justice can start the criminal indictment. And this could be serious because at this settlement, Olympus was also was obligated to pay $646 million in that huge amount of money. So then, just 2 months after the signing of the deferred prosecution agreement, there was a scoop of Shenzhen bribery. First, in April 2016, the New York Times scooped this Shenzhen bribery issue in detail. And 2 more months later, Japanese media Facta also scooped this Shenzhen bribery issue and also publicly released the report of the Olympus's internal investigation. The investigation report concluded that no violation was found, but this was contrary to the memoranda which OCAP Legal received in 2014. Also, this report says that this report doesn't provide a legal opinion, just for the factual investigation. And also, there's no assurance of that this conclusion of the report will be the same as the Department of Justice's understanding. So, yeah. And that's 2016. In 2017, the Department of Justice took another action in duodenal scope issue. As I said, the duodenal scope issue is ongoing investigated, and there was a meeting in June 2017 between Olympus Council and the Department of Justice. The purpose of the meeting was for Olympus to present their remedial efforts in the duodenal scope issues so that they can proceed to the settlement negotiation, just like what they did in the anti-AKS investigation. But in response to Olympus's presentation, the Department of Justice gave some comments, which it's partly also written in the Financial Times article today published. I would like to just briefly read that part. And what we've seen in this case, while the process has improved, the problems in lots of the incidents in this case were not process issues, but judgment issues, where there was a cultural attitude where something happened, but there was the sense that it couldn't be the device's fault. The cultural view is what led to the problems more than the process issues. What is being done to fix that? It goes beyond our RAQA, because it is notable for everyone that as we sit here and hear about this transformative work in terms of RAQA, it was 2 years ago that we sat in a similar room and heard about the efforts company was making in response to anti-kickback and FCA issues. And notably, much of what went on in this case, virtually all of the conduct at issue now took place while we were overt on our AKS investigation. While the company understood they were being investigated and knew that the government was looking at the company, all of these bad judgments were made. And while the company was undertaking substantial and necessary changes to be able to put forward a new compliance program here and abroad, that analysis clearly missed that there was changes needed from an RAQA perspective. What is the company doing from a cultural perspective so that we aren't here 2 years from now with another issue? So this is what the Department of Justice said in the June 2017 meeting. And now, I believe that the settlement negotiation is not still went on in this duodenal scope issue. I'm not sure what the Department of Justice is thinking, and nothing's for sure, but I felt that the Department of Justice is monitoring these three issues: Shenzhen bribery, DPA issue, and duodenal scope issue. And through this comments, I felt that the Department of Justice is implicitly questioning Olympus's attitude in the Shenzhen bribery issue. That could be the cornerstone of Olympus's culture of compliance and also the corporate governance. Indeed, this year, also OCAP Legal obtained 3 memoranda from U.S. law firms and Chinese law firms: Kravis, Swain and Moore, Hughes, Hubbard and Reed, and Deloitte Legal in China. All again pointed out high risk of FCPA violation, and also some memorandum pointed the conflict issue in the Olympus's internal investigation committee. So that's the story of these 3 combined complex issues. And I learned this by discussing with OCAP legal manager. His name is Shuichi Oda. And also through my personal knowledge in handling duodenal scope issues. So my opinion is still the same, is that the Shenzhen bribery issue should be reinvestigated fairly, thoroughly by the independent investigators, not by the not just relying on its previous internal investigation. It is important to really check and detect whether there is FCPA violation, and also reporting to the Department of Justice. I believe there's a merit in this recommendation because from Shenzhen bribery issue, the company can seek mitigation credit in future potential penalty based on the FCPA corporate enforcement policy. In DPA issue, the company is required to self-report this FCPA violation under the DPA, so it also mitigate the risk of breaching the FCPA in DPA issue. And lastly, for the duodenal scope issue, it can directly show the Olympus's culture of compliance, which the DOJ questioned. And also, since this Shenzhen bribery issue involves Olympus management, including Sasa, Takeuchi, Hirata, I believe that this reinvestigation should be led by outside directors who are not involved. That includes Mr. Hiruta, Mr. Fujita, and others from other directors. Since I contacted with Mr. Oda, and luckily I had a chance to contact with all outside directors. Actually, this was based on actually following the DOJ's questions of the culture of compliance. Olympus planned to provide the presentation in the compliance culture. And I was assigned to prepare for that presentation. And I recommended to hold an interview of outside directors, showing that Olympus is not also receiving knowledge and expertise from the outside management. And I interviewed all outside directors, and through that I decided to contact Mr. Fujita from Itochu Corporation, and I sent him a letter. I met in person. I provided the memorandum, Kravitz, Swain, and Moore, explained the Shenzhen bribery issue. And after then, Mr. Oda and I met Fujita-san. He also explained the situation and asked Mr. Fujita to take the leadership and handle with this Shenzhen bribery issue. But unfortunately, he didn't take enough leadership. Instead, the next month, Mr. Oda was suddenly transferred a new unknown division, really unnatural. So I felt this was highly likely the retaliation against him. And I wasn't, at that time, I was secretly supporting him. But after he was retaliated, I decided now it's time for me to do my job. So in June 2017, I sent a letter to all outside directors attaching my legal opinion summarizing the 5 memorandum and also the problems, issues in the internal investigation report. And in conclusion, I recommended to reinvestigate. But again, unfortunately, outside directors didn't take sufficient actions, and I was also retaliated. And based on that, I filed a lawsuit this January. So that's the story until now. Still, the Shenzhen bribery issue is ongoing, maybe. I mean, the factory is closed, but also OSZ is ordered to pay huge amount of money. And in duodenal scope issues, the company recently announced to put the reserves, but I don't think that would be sufficient to finish the duodenal scope issue. So I believe there's still high risk in that company. And I strongly hope the company should deal with these issues properly to show the culture of compliance and also the rebuilt corporate governance. And lastly, in the speech summary, I just pointed out, I just listed what this new Olympus scandal means. First, even under the new management, there was illegal conduct. And Mr. Sasa, Takeuchi, Hirata, Mr. Kimoto, Mr. Fujitsuka, all were involved. And also, the outside directors, I listed the names in the speech summary. Mr. Kimoto, Mr. Fujitsuka were directly involved. Maybe they were directly involved in retaining an APT. And Mr. Hiruta, Mr. Fujita, Mr. Katayama, Mr. Kikawa, Mr. Kaminaga, Mr. Iwamura, all hasn't taken action. I mean, I am not sure what they're thinking, but I don't think they are doing their job. And of course, the important risk is, of course, the monetary risk. Like in Shenzhen bribery, you all might know that the FCPA violation could be in a huge amount of penalty. And also the breach of DPA settlement, which required $646 million US, that could be also a big risk. And ongoing duodenal scope issues, there's already more than 40 litigations pending, and I believe that some of them might go to the trial. And at the same time, the DOJ investigation on the duodenoscope issue is ongoing, and all those issues could be a risk. And again, as a conclusion, I strongly hope the management should do their job, take the responsibility, and do the right thing for the companies to avoid tragedy. I guess I have spoken enough. Maybe my English was a bit weird and maybe not accurate. So if you have some questions about my speech, I'm free to answer that. If not, then anything you have question, please feel free to ask.
Yes, thank you very much. And your English was great. Thank you very much for doing it in English. Okay, so I'm going to open the floor to questions, and we'll take them down here. So does anyone have a question? Okay, let's start with the working press table here in front. Yes, can you come up to the front and tell us your name and where you're from? And then we'll do the translation as well.
My name is Steve Barker from CLSA Securities. Thank you for your presentation.
Sure.
I was interested in your comment about your view on the money that Olympus, the reserves that they've prepared in preparation for potentially some fines exacted by the DOJ related to the duodenoscope issue. I think you said that you didn't think those funds would be enough. I was wondering if you could just elaborate on that a little bit more. Why don't you think that's going to be enough? And if you've got a view on how much would be enough, that would be very helpful.
I'm not
Thank
sure
you.
because I was assigned to the duodenoscope issue, but that calculation of the fine was actually shared among much more high management. And I remember that the company hired consultants in U.S. to evaluate the possible fines, but I've never seen that report. So, I can say, but as I read the press release of the recent company's recent release about the funding, that sentence was a bit different from the previous press release on the DPA settlement. In 2015 or so, I think, Olympus also press released the funding for the DP anti-kickback settlement. But they said that the company is continuing discussion for the settlement with DOJ. But the last press release on the duodenoscope issue, there was no words of that settlement negotiation. So that's one of the maybe clue to find out if company's press release is enough.
Right. So
only the guess.
Right. So your view is that the settlement could actually be a lot higher.
I think so.
Thank you.
Only my personal guess, but I think.
Thanks very much.
Thank you. Okay, yes.
Thank you very much. Satoshi Sugiyama with the Japan Times. You described about, in your press conference, about the retaliation against you. Could you elaborate what was that? What was the retaliation?
So, following chronology, on December 6, 2017, I sent an email to all outside directors attaching my legal opinion. Then after then, I forwarded that email to all members in the legal department to show what is ongoing with Mr. Oda, and also sharing my whistleblowing to colleagues. And then maybe on December 13 or 14 or so, I also forwarded my email to the compliance department and HR department for objecting that and also on December 20, I also forwarded that email to, I guess, 300 or 400 employees in the Shinjuku office building. That's also copying all the directors. The reason I did this is because that I wanted directors and managements to do their jobs, not hiding, but openly. And all the Olympus employees are watching their job. That's what I intended to do. But then, suddenly, the defendants, Mr. Kikuchi and Mr. Matsushita, suddenly ordered me that they will stop my email, company's email, deleting my access to the company's email server. So that's the retaliation. The reason they did this is because that information will be leaked, and that is trade. One of the persons said that's a trade secret, but I don't think that's a trade secret. I mean, this issue relates to the violation of law. And I am a Japanese lawyer and understand that cannot be the trade secret. And that's the story.
Thank you.
So one more, could it be, I believe this is a retaliation. So as I said, the last June, the company stopped my access to the email server, and this January, I filed a lawsuit against the company, and then after, on April or so, the company announced me to start disciplinary process. And I provided my comments, but the company decided to stop 2 days stop me to go to the company for 2 days. And moreover, then company locked me out. And I remember that this is not authorized under the employment rules of Olympus. And the company said in that announcement, in that paper, that they will do some additional disciplinary action or transfer movement later. So there should be some kind of action. I think it cannot authorize for me to lock out of the company for so long time. Thank you.
Thank you. Okay. Do we have more questions? Yes.
Thank you, Mr. Sakakibara. My name is Yasu Sawa from Kyoto News, Japan News Wire Service. Thank you very much for a very impressive presentation. My question is, firstly, obviously Olympus has paid so large amount of money under the table in Chinese scheme. So is there any clue for us to find out what is wrong and what is manipulated in the public document, like a financial status of the Olympus? Do you think it is possible to for us, as a reporter, to find out something wrong in the disclosed document? Do you think it is possible to find them out from the public document? Can I say, oh, this is wrong, or this is strange, or something like that?
That's, I guess, a difficult question, I think. The internal investigation by the Olympus actually requested support to APT in sending some letters, but actually the APT refused further comments, just said that they took the legalized options to solve the issue, only that. And under that limitation, the report concluded no violations found. But this is it's just much more a legal analysis. But the Baker and McKenzie memoranda, I remember, said that the U.S. Department of Justice is almost likely to find that those payments were paid to the government officials according to FCPA analysis. So that's what I can say.
And my second question is, since you have filed the lawsuits against the company, do you have any prospect that in the lawsuit you can make them disclose more information public in court?
No, unfortunately, no, I don't, because the company is trying to minimize the issues to be discussed in the litigation. Just alleging that I made the wrong use of the email, so that's why I shut it down. That's the company's position, and so they are not submitting meaningful evidences. That's the situation.
So they are not. They are narrowing the scope of your discipline issue, like
Yes.
misusage of the company's email system.
Yes, that's right.
Thank you.
Okay, are there more questions from working press or non-working press? Yes, in the back.
I am Tina Saunders, a law professor at Temple University Japan campus. Thank you very much for your very informative presentation. I wanted to ask a follow-up question to the gentleman's previous question. Can you give us more background about the lawsuit that you are currently engaged in? So what court did you file in? What are the actual allegations? And can you tell us where in the process?
Okay. So this January, I filed a lawsuit. My complaint is publicly released in the FACTA website. It's in Japanese, so my allegation in the complaint is 2 points. One is bullying. That bullying can be, under Japanese law, it could be a tort liability, and also duty of employers, but that's the right direct cause of action to file the complaint. But actually, through the complaint, I also try to illustrate that Mr. Oda's transfer is illegal. I mean, it's the retaliation against his whistleblowing. And also pointing that the Shenzhen bribery issue could be in a violation of the law. So my complaint is, my final ultimate goal in my lawsuit is trying to describe the potential violation of law in the Shenzhen bribery, and the company's action against those men who voiced the risk is illegal. And again, the action against myself for voicing that illegal action is also illegal. So that's the story. And so that's the content of the complaint. And so we had a court hearing for 4 or 5 until now, but the judge is still not giving detailed direction to how to proceed the litigation. But so we have a next court hearing in Tokyo District Court, as I think December 10th. And actually, the Japanese Tokyo District Court said maybe they can exclude this OSZ issue and also Mr. Oda's transfer issue out from the scope of this litigation. That was against my expectation, but the judge said, bring it to another place. I'm not sure what that means, but that's what the court said.
And one last question related to the lawsuit. Is there any defense by Olympus that there was a violation of an NDA, a non-disclosure agreement by you, or in that way to protect private internal information of the company?
Well, I haven't received official complaint about that, but through their brief, the company warned me of potential violation of confidentiality, a kind of warning.
Thank you very much.
Yeah.
Okay, did you have a question?
Hello. My name is Yuko Takio from Bloomberg News. I have two questions. First, could I get your views on Japan's current whistleblowing laws, especially the 2006 whistleblowing laws? Do you think it's adequate? And second, whether you think the current corporate governance code helps whistleblowers at all?
So the first about the whistleblowing laws, actually I'm not specialist, but my legal counsel of my lawsuit, his name is Kozen Koichi, he is the actual specialist in the whistleblowing law, so maybe he's much more qualified to give some comments on that. But my personal comment is that this is the matter of not just the structure of the law, but rather actually how to use that law. So the law says that whistleblowing is protected, but even the law says that it's the problem how the people, whether people follows that law. And what I've seen in this case, like Olympus, there are some news articles saying that the compliance helpline of Olympus has lots of reporting, so it can be a good demonstration that the Olympus has good compliance. But I don't think that. Actually, the matter is how people act when they face that issue. That cannot be solved by law, I think. And also the corporate governance code. That's also the same. Of course, I do understand the efforts to improve the corporate governance through the legislation or all those things. But the problem is how the people, human, act. I think that. So it's a bit, I guess it's not a good comment to your question, but that's my that's my sincere comment.
When you say how people act, are you talking about will people do whistleblowing, or how the people around them in the office will treat them after they do that? Which people are you talking about?
The latter. Oh, so how the people face when the whistleblowing, I mean.
How people will treat them.
Yeah, how people treat that.
You think that's important?
Yeah, I mean, so my whistleblowing is, there are some people who would follow their ethics and do their right things. And the problem is how people react to those whistleblowing.
Thank you.
Yes.
Thank you for your presentation. I'm Christian Howes from SMBC Nikko. I was interested to know how Mr. Fujita reacted when you met with him. I mean, it wasn't like you just sent him an email and you didn't have a chance to see his reaction. So do you have a sense that he was internalizing and thinking about what you wrote and perhaps disconnected from similar corresponding information within the company? Or do you think he kind of had information at the board level or being communicated through his management level?
Yes. So the first I sent a letter to Fujita-san, which describes the three issues I said, and after then I met him in person in his room in the Meiji University. He teaches some lessons to students in Meiji University, and then I gave him the memoranda and explained the summary of the problems, and that the second meeting, also in the Meiji University office, Mr. Oda and I met him, and Mr. Oda is actually directly involved in this Shenzhen issue, so he explained all the stories, and after then, Mr. Fujita said, I already heard this whistleblowing, so I have to take an action as the director. And I would like to first tell this, speak to Sasa first, and then maybe Mr. Hiruta, because Mr. Fujita and Mr. Hiruta are both were working on Olympus as the outside director since 2012, so they both know what the Olympus is. And that's what I've heard. And later then, sometimes I had a telephone call, and Fujita-san told me the situation. But Fujita-san told to Sasa that the company must deal with the Shenzhen issue seriously. Then Sasa said that, yes, we already recognize that, and we retained another counsel for the reinvestigation. That's actually Morgan Lewis. And I heard that the Morgan Lewis lawyer attended at the board meeting and explained his analysis to directors, including Fujita-san, Hiruta-san, all those folks. And he commented that, well, there was some questions raised, but nobody objected that analysis. That's what I've heard. But that's all. And all the outside directors including Fujita-san, never contacted me after I filed the lawsuit. That's what Fujita-san is doing.
Thank you very much.
Welcome.
Thank you. Okay, I think we have time for one more question, if there is one. Yes.
My name is Ito from Hachima Steamship. You have filed a lawsuit against the company, right? And has there been any reaction from the company so far? And if the company is being still silent, what kind of action are you going to take next?
Is that in terms of my employment or the litigation?
Litigation.
In terms of litigation, there was no counterclaims or other filings. So I think the company is just silently continuing the court procedure of my lawsuit. And if even that still continues, I have no plan to do next yet. But aside from that, I just wanted to say the company should deal with the three issues, what I said. My lawsuit is just some kind of a,
Way to focus attention.
I see. And just one more question is that you had a strong supporter like Mr. Oda within the company, but are there still any supporter within the company now?
So this is my understanding, but there are many good people. My view, there's many good people in the company, but they cannot raise the voice because of the retaliation, because of the management, the supervisors are all pressuring, and they cannot raise the voice, and that's what I think that that company is now carrying, and so this is my. So my lawsuit is kind of like those picking up those voices and trying to tell to the society or public. That's my role.
So that means you still have to act as a lone wolf, right?
Well, anyway, there is sometime this will end. Maybe I will lose, maybe I'll win, but and also there's 3 issues may close. I don't know what kind of a way it would end, but I think that this is my last job in the Olympus Corporation. I guess someday I'll leave, but as far as I'm the Olympus employee, I would like to do the things that could be good for the company, and I think that company needs. And I hope that also fits with company's benefit.
Thank you very much.
Okay. Thank you very much. I think that's a nice place to close. Thank you again for coming. We all really appreciated you taking the time, and it was a very, brave thing of you to do to come here and talk about all this stuff. So thank you again.
ありがとうございました。